Thank you, Mr. Chairman. The Constitution deliberately separates the powers of the federal government in a system of checks and balances. Article 1, Section 1 vests all legislative power in Congress, while executive power belongs to the President and the judicial power rests with the courts. This foundational structure ensures that no single branch dominates the other, safeguarding individual liberty from government overreach. But for decades, the executive branch has taken legislative power by issuing regulations that carry the force of law. In 1984, the Supreme Court ruled in Chevron that courts must defer to an agency's interpretation of an ambiguous statute, rather than exercising the independent judgment to determine what Congress actually meant. The deference allowed unelected bureaucrats to wield immense legislative and judicial power and issue sweeping regulations with little accountability. In 2023 alone, unelected bureaucrats finalized over 3,000 rules. By contrast, during the same period, Congress passed less than 70 laws. This means the executive branch agencies impose more than 44 times as many mandates as the actual legislators. The consolidation of power within the executive branch directly contradicts our constitutional framework and harms American liberty. It is certainly not what our founders intended. And the regulatory state is not just oppressive, it's costly. According to the Competitive Enterprise Institute, the total annual cost of the federal regulation is now $2.1 trillion, equivalent to over 7.5% of U.S. GDP. If members of this chamber impose that kind of cost on taxpayers each year, we'd be voted out of office. Fortunately, the Supreme Court has finally restored the judiciary's constitutional role in interpreting the law. In a 2024 case known as Loper-Bright, the court explicitly overturned Chevron. The Supreme Court held that under the Administrative Procedure Act, courts must exercise independent judgment while reviewing whether an agency has acted within its statutory authority. As Chief Justice Roberts, quoting Alexander Hamilton's Federalist No. 78, wrote in the majority opinion, the framers, quote, envisioned that the final interpretation of the laws would be proper and peculiar province of the courts. He went on to note that the Administrative Procedure Act, quote, incorporates a traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions, end quote. In other words, the Supreme Court has now recognized what we in Congress have long understood. Chevron was an abdication of judicial responsibility that allowed agencies to run roughshod over both the Constitution and the will of the people's representatives. But while Loper-Bright is a major step in the right direction, it does not resolve all questions of judicial deference. The court left open the question of whether other deference doctrines should be overturned. And courts may very well find ways to invent new deference doctrines if we do not stop them from doing so. That is why it remains imperative that Congress act to solidify the judiciary's duty to review agency action and ensure that the executive branch cannot continue to legislate outside clear congressional direction. That is why we must pass H.R. 1605. Separation of Powers Restoration Act would formally codify the Supreme Court's decision in Loper-Bright and invalidate any other precedents that require courts to defer to agency positions. This will ensure that courts independently consider what Congress has said through its statutes rather than putting a thumb on the scale in favor of the federal agencies. By requiring courts to apply de novo review, this legislation would ensure that judges exercise their constitutional duty to interpret the law independently, rather than deferring to the very agencies whose authority they are supposed to scrutinize. I urge my colleagues to support this critical legislation and restore the balance of the power demanded by our Constitution, and I yield back.